Well, thank you, everyone, and welcome to tonight's asset protection webinar. We've been teaching this series for, I think, going on 15 years, maybe a little longer. I don't know how long webinars have been around. It was a new concept when I started doing this, but we've got quite a series and hundreds of hours of recordings. Most of them are on our YouTube channel, or sometimes they come in and out a little bit. We're not quite like Disney that pulls things out and puts them back in, but we do rotate them. Just I don't know why we do it, but we do. But there's a tremendous library of webinars that we've done in the past. But I'm really excited about this one. In the past few months, we've had Derek Long talking about IRAs. We had Kevin O'Leary. It's been almost a year now, but that was 2 weeks ago. We talked about protecting IRAs and what is ERISA protected, what is not ERISA protected, and if your IRA or your TSP plan is not covered, how do you keep it from blowing up on the inside, and how do you protect it from outside? And so we had a pretty good discussion about that, about divorce and intellectual property. And we just so many different topics related to asset protection. And we've had some tremendous speakers. So if you're not plugged into that, pay attention to those, subscribe to our YouTube channel, and you'll have access to all that. We've got 2 summits coming up that we're now taking registrations for. This is our big event where we really do try to bring the best of the best from the financial industry together. Clint Coons, of course, from Anderson Law Group, Scott Estel, former senior trial attorney from the IRS. We rotate several different real estate speakers to keep you informed of what's happening in the market. Bill Danko, co-author of The Millionaire Next Door. And we're just bringing some of the best every time we teach one of those summits. We are taking registrations. There's room in the June event and the July event. We used to charge, years ago, it was $3,000 to attend the class. Now with Zoom, we open it up and we don't have the travel expenses. So we waive tuition. The only thing we ask is you give us 3 days. Don't come in and learn half a legal strategy and then go get a sandwich or open the, see what mail came through, or I don't know. Just give us 3 days. And if you can do that, we are really good at teaching asset protection and some really cool strategies, tax strategies you may not hear anywhere else. We've got some amazing speakers, and so I encourage you to take advantage of that. You'd sign up for those at our website, protectwealth.com. And then we've recently added a whole bunch, it's a whole series we've been posting on Facebook and just tax tips that you got to be paying attention to. And we'll every week or so we're posting a couple more, and then it's just social media posts, but we put a little time into that. Okay, before we get into this topic, and I'm really excited about this, there's always a legal disclaimer. Whenever we're talking tax and legal, we can teach general principles, but do they apply to you and your situation? I have no idea. And that's why you always take these with a little grain of salt and say, learn the principles and then talk to a professional and see how they apply to you. And with that, let's talk about the topic. And I'm so glad to have Jonathon Evans, an attorney out of Anderson Law Group, with us tonight, because the topic, several years ago, Congress changed the law. When I started teaching this, any estate over $675,000, you'd end up paying estate taxes on, federal estate taxes. And then it went to $1 million. Oh my gosh, that was such a godsend. And then it went to 1.5, and then it eventually went up to 5 million. And then, oh my gosh, it went to 10 million, and that's been indexed over the years. And now it's up to 13 million, but that's going to sunset. And what are we going to do when it sunsets and it comes back to, I'll let Jonathan take so I think it's around 5 or 7 million. I think it's 5 million indexed up, whatever it is. But we used to use a lot of charitable remainder trusts. We used to use irrevocable life insurance trusts. We used other things to move assets out of your estate so that they wouldn't be taxed on the federal level. Some states have adopted what they call pickup taxes, meaning if the federal government's not going to charge it, then we will. And so avoiding estate taxes on the state side and inheritance taxes has also been a big issue. And so, but what happens when this current law goes away? And if it does go away, and what do we do and how can we plan for it? Such an important topic. We're glad you're here. And Jonathan, we're especially glad you're here to share your expertise. Jonathan, I'm not going to give you all your background. I'll let you do that. But I'm excited about the topic and excited to hear what you have to say. So we're going to turn time over to you. He'll take questions probably at the end. And so what I'd suggest is write your questions down, or as you go through, I'll let him explain the topic and then put in your questions, because we're going to address the questions at the end. And my guess is he'll probably cover most of your questions in a logical, sequential manner. And then we'll stay and answer your questions, but give him a little time to cover the topic. And then I think we're happy to answer questions. So with that, Jonathan, welcome. Glad to have you here.
Yeah, thanks, Don, for that great intro. Let's see here. Let's grab the reins and we will be off. Okay, perfect. All right. Yeah, so happy to be here, guys. I think we're going to have a lot of fun tonight. Just like Don said, basically, we're talking about what we should be doing with our estate plans now in 2023. We've got this big change to the estate tax come down the pipeline. What does that mean for us? What should we be doing about it? Now, I like to think of this as more of like a training rather than just a presentation. So just like Don said, if you guys have questions, feel free to throw those in the Q&A. Most likely I'll be getting to those near the end, but if you do have any burning questions, anything like that, don't worry. If it's in the Q&A, I'll take a look at it and we'll get that addressed for you. Now, we're also going to have a really interesting opportunity for people who are either attending this live or watching the replay, listening to the replay. It's an offer that speaks directly to what we're going to be talking about today. So if that at all sounds interesting, definitely worth sticking around to check that out at the end. Now, because I'm going to be your instructor for today's training, let me tell you a little bit more about myself so you can have some confidence in what we're doing. So just like Don said, my name is Jonathon Evans. I'm one of the estate planning attorneys with Anderson Business Advisors. And after working 8 years in estate planning, 3 of them in particular with Anderson, I've seen what a huge difference this kind of planning can make in the lives of investors and their families. I love talking with a group of people like you guys who want to learn how to protect and preserve your legacy. And I know we can learn a lot today. Now, I did mention that I've learned how important this planning is for investors during my time here at Anderson in particular. And one of the reasons for that is because of how Anderson is set up. Now, at Anderson, we're not just about estate planning. We actually help investors protect their assets, reduce their taxes, plan their businesses, and plan their legacies. And we're different from other firms because we bring all of that under one roof, right? You're not just going to hear the attorney side or the CPA side or the financial planner side. We're all here together, talking with each other, keeping everybody on the same page. We're also investors ourselves. So we bring that investor's perspective to the table alongside all of that. With that said, though, my favorite part of working at Anderson is the fact that we're really big on education. We found that educated clients just make the best decisions, and they're also the easiest to collaborate with. It really allows us to work in step with our clients and put them on a better path. And that's, again, why it's awesome to be able to spend time with people today who are willing to take time out of their day to learn about this stuff. So here's the big picture of what we're going to be doing today. Now, you guys know that building up your investments is just part of a good investor's journey. You know that for us as investors, it's just as important for us to have a plan for those investments when we pass. You need to have a plan for life surprises, like how to protect your kids if your spouse remarries when you die, or how to protect your kids if they get into a nasty divorce so their ex-spouse doesn't take their inheritance. I'll show you how to keep that from happening. You also need to have a plan that's going to protect you and your estate from attorney's fees. So more money goes to your heirs. It's not getting diverted into the attorney's pocket. Because the average person out there, their estate's going to spend somewhere between $14,000 to $30,000 on legal fees if they're not set up right. And I'll show you how to avoid that. You also need a plan that's going to preserve your values. And this is something that people don't always think about. You know, those values that are truly important to you, you can actually pass that down as part of your legacy. There's a way to build that in with incentives, with opportunities that you can create for your loved ones using the right kind of plan. And I'll show you how to do that too. So step back and let's think a little bit. You know, think about how good it would feel to know that all of your hard work, your sacrifices, your legacy, it's going to be built into a plan that's going to have a lasting impact on your family and your community. You can think about how good your family and the people benefiting from your legacy are going to feel when you hand that legacy down in a way that protects them while preserving those values that you have. Imagine that peace of mind that that's going to bring. Now, if that's something that you want, then you're in the right place, because that's exactly what we're going to be learning today. Protecting our legacies so they can really make a difference. Now, some of you might be thinking to yourselves, it's probably a little early for me to be doing any of this kind of planning. I'm just getting started. I don't have enough to really need an estate plan. I'm just going to listen now, so I'm educated and I know my options when that need arises. But for now, I'm just going to hold off on doing any of this until I've actually got something worth calling a legacy. But here's the thing, though. Getting your legacy planned is the beginning of the journey. And I'll show you what I mean. So now picture this, right? So we've got a young family, let's say, who's just getting started. They just got their first house. They're really excited for this new step in their journey. And they're thinking about installing a security system to protect it. Now, is it better for them to wait until they've actually got something in the house worth stealing? Or is it better to get that alarm system set up? You know, get the sign on the lawn, get the stickers in the windows before they start moving in that art collection they've been dreaming about, or that jewelry, or that 90-inch television that they want to buy. Now, some of you might be thinking, well, he's missing the point entirely. The alarm system's great if you've got a bunch of stuff, but its real purpose is to protect the people in the home. They're the real priority. And you're right. An estate plan works the exact same way. Of course, it's necessary if you've got a bunch of stuff, but its real value is to take care of the people in your life. And it's never too early to do that. Now, oddly enough, you'll even run into these other advisors out there who'll try to talk you out of putting together an estate plan because you don't have enough stuff. Now take a moment and imagine this. Let's say that you called ADT out to come install an alarm system in your home. What if the ADT guy shows up and he starts walking around the place, just kind of looking around, and he's got this general disapproving look. He comes back to you and he says, I appreciate that you guys are interested in our business, but there's nothing here worth stealing. So you don't need this. Tell you what, I'll give you some stickers. You can put them in the windows. We'll call it good. That's really all you need right now. And then you can call me when you've actually got something that's worth my time. What would you do? Like, can you even imagine somebody doing that to you? I mean, the first things first, you tell them to get lost, right? At minimum. And then, geez, after that, who knows? And yet, we are perfectly fine letting advisors do this exact kind of thing out there with estate planning. They'll tell you not to put one together, or instead of putting together a proper plan, they'll set you up with something inferior, like a will. Now, after 8 years as an attorney practicing in this area, you can understand how often I've heard horror stories of this happening. A while back, I was actually helping a client put their plan together. And normally, as I'm introducing these concepts, I give people warnings. So they've got, the ability to make these informed decisions. And I warn them about, there's these risks out there. If you do the planning wrong, if you use something like a will. And so as I started getting into that, they actually stopped me and they said, hold up. I know all about that. You don't need to get into that. My dad went to an attorney to get his planning done, and the attorney told him he didn't have enough to justify having a proper plan, so he just set him up with a will, basically made the choice for him. The attorney said it was going to be simpler and it was going to be easier, but it wasn't. This client said when dad died, it was such a nightmare settling his estate with that will. I wish the other attorney would have given him a better option instead of just making the decision for him. But I know better now. I've seen it done wrong. I had to put up with it, figure it out. I'm not going to do that. I'm not doing that to my kids. Talk about a lesson learned the hard way, right? Now, there's one last little thing I want to touch on here before we really get into the meat of what we're talking about today. And it's something that not a lot of people know, and it can be really eye-opening. Lawyers actually have a financial incentive to push people out of trusts and more proper plans like that and into wills. And I'll tell you a bit more about that here later on. But now we're going to shift gears a little bit. We're going to start talking about the big elephant in the room, the thing that Dawn was talking about, that big threat to our legacies that's on more and more people's minds these days, the estate tax exemption sunset. Now, that's quite a mouthful. What does that mean for us as investors? Well, in the simplest sense, there's potentially this big change to the federal estate tax on the horizon. A lot of people are worried that it's going to create a new tax problem for them. Right now, if you pass away with about $13 million or less in your estate, you don't have to pay any federal estate tax. If you're married, that amount actually gets doubled. So if you've got 26 million or less, you don't have to pay any federal estate tax either as a married couple. So a lot of people don't need to worry about this right now. But on January 1st, 2026, those numbers are set to get cut in half. So if you've got more than about 7 million in your estate at that point, or 14 million if you're married, then there's a risk that you're going to get hit with the estate tax. And that can be up to a 40% tax rate, depending on how valuable your estate is. So like I said, you can see how a lot more people are worried that this is going to create a tax problem for them. On top of that, there's a lot of people out there trying to drum up fear and anxiety over these changes so they can sell products or services to fix the problem. And if you're in that boat, if you're hearing that noise, feeling that fear, that anxiety, you're going to want to pay close attention to the next two things that I tell you, because they're going to give you clarity on the issue, and they're going to help you make better plans for your estate and your family, plans that are not going to have unintended consequences. Now, the first one, this one's pretty simple. January 1st, 2026 is still a long way off. These changes are happening because a tax break from 2017 is expiring. It's not because Congress is proactively stepping in and passing laws to make the estate tax worse. It's just something that was created a while back and it was set to expire, and they haven't stepped in to change that yet. Now, not only do we have a few years before the tax break expires, we've also got a general election. And I don't know about you guys, but to me, the political landscape out there seems more and more uncertain, I guess is a polite way to put it. So who knows what's going to happen in 2024. So in short, there's still plenty of time for Congress to act again and either extend these tax breaks or make them permanent. So we don't want to do anything crazy just yet. Now, the second point I want you to keep in mind, and this is the big one. If this is your big takeaway for today, great. It's the only thing you remember. I've done my job as far as I'm concerned. What these fear mongers out there won't tell you is that the solutions they're offering to this problem, they're a one-way street. They can't be undone. I recently spoke with a new client who'd gotten caught up in this kind of planning, this fear-based planning. And he had this large ranch property that had appreciated a ton in value. He found out that the tax break was expiring, and this property all by itself was going to push his value of his estate up above the new limits. And he was going to get hit with this estate tax problem. Now, when he went to his previous advisors, they fed into his fears and they told him, hey, you got to gift this property to your kids before it's too late. Because if you wait too long, you're going to get stuck. No, so gift it now and you get to take advantage of the tax break before it's too late. Now, unfortunately, the rancher listened, right? He went to his advisors. They should have been telling him what to do, something that was good for him, not just good for them. He gave into the fear. He gifted the property to his kids. What the advisors didn't tell him, though, was that gifting the property like this would be permanent. Once he gifted the ranch to his kids, he cut off all of his other options. The fair market value of a gift that you make while you're alive eats into your estate tax exemption. It eats into that tax break, and that can't be undone. So he permanently used up a huge chunk of his tax break following this plan, and he was finding out that you can't undo that any more than you can unring a bell. I had to explain, there's no do-overs when it comes to this kind of stuff. The rancher, unfortunately, had chosen to give into the fear and the panic, the encouragement of these other advisors, and it ended up being a tough lesson. So, like I said earlier, you guys can see how this stuff puts things into perspective, right? It puts those fears, that anxiety to rest, and you guys see that you don't have to give into this fear-based planning, and you shouldn't, because it can really mess things up for your estate and your family. Instead, you guys know that you can take a breath, you can step back, and you can take the time to do some proper planning so you're ready if the tax cuts do expire, but you're also not going to be hurting yourself or your family if Congress does extend the tax cuts. So we just went through the estate tax sunset, what it means for us as investors. This is something that a lot of people out there don't fully grasp, so they panic. But by now, you guys know that you don't need to panic and that you've got time to do this proper planning that you need to do. So I hope you guys got some value from that, because when you understand this stuff, you can make better choices and keep yourselves out of trouble. So now let's talk a little bit about what that proper planning is. What should we be doing right now? So proper planning, what does that really mean? Proper planning simply means that you're looking at your legacy from all the angles, not just one. Sometimes people, they get really worked up about one particular angle, and they'll come to us really worked up about something like the estate tax, but that's just one part of the plan. And as we saw, it might not end up being an issue for you depending on the size of your estate and what Congress ends up ultimately doing. There are a lot more angles out there to look at, a lot more issues out there that apply to everyone's estates, regardless of the value. And these are issues that Congress doesn't have any impact on, so we don't need to worry about what Congress is going to be doing in the future. Now, unfortunately, the biggest issue, the first one that I want to talk about here, is people just don't think about this stuff. I've heard people say, I'm still too young to think about this. I've got plenty of time left. I don't want to get into that right now. I don't need to worry about this right now. But all you need to do is pay attention to the news to see why this mindset can be a problem. There's actually a couple tragic examples in the local news here in Utah recently. This past fall, a gentleman went out to his detached garage to work on a project early one morning. This was something that he did all the time. Now, with the change of the seasons, the garage was a little cold that morning, so he got out his propane space heater, went to fire it up, just like he always had. But this time it malfunctioned, and he was gone in an instant. Another tragic example happened earlier that same month. There was a teenager that randomly broke into a young married couple's home. He went right into their bedroom and he just started attacking them. The police haven't found any connection between this couple and their attacker. It's just a completely random act of violence. And this stuff happened in Utah, of all places. And Utah isn't known for being a particularly wild place. So tragedies like this are awful. They really are. But they're also a heavy reminder. They put everything into perspective. We know that life is short, but sometimes we can forget that it can be shorter than we're expecting. Now, of course, the odds are that the average person out there is going to die of old age, not a tragedy like this. But think about it from your family's perspective. Your death is still going to be a tragedy for your family, even if you do die peacefully in your sleep. Think about how they'll feel if there are legal issues on top of your death that they have to deal with. Think about how they'll feel if this plan that you put together or don't put together winds up with them having to go to court to settle things. On the other hand, think about how your family will feel if in the midst of their grief, they find that your plan keeps the court from getting involved, keeps things simple for them. It keeps it private, makes it easy comparatively, right? Then there aren't going to be any extra headaches or surprises for them to deal with. Imagine the kind of relief that that's going to bring them, discovering that you paved the way to make things easier on them in that tough time. So have a game plan for your death. The planning that you guys do today will have a huge impact on your loved ones. You can choose to either put together a plan that's proper, that makes things easier on them, or you can ignore the issue and leave it up to chance. I know the mood's a little heavy, so let me lighten it just a little bit with some funny reasons why you should have an estate plan, why you shouldn't leave it to chance. Now, I bet a lot of you guys already have estate plans, which is great. But for those of you who haven't put one together yet, maybe these reasons that I'm about to share will give you that extra little nudge that you've been looking for. Now, these reasons are real people and real situations that I've run into in my life. They aren't make-believe, believe it or not. But I have changed the names, so I've got plausible deniability. Now, the first problem that we're going to talk about, we're going to call him Richard, okay? Picture this. Richard is your oldest son, right? And he thinks really highly of himself. He figures he knows exactly how your estate should work, exactly how you should be managing your affairs. Now, one day, your youngest daughter comes to you and she asks you to tell some stories about your late father. You know, he's passed away for quite a while ago. But as you're telling these stories, you remember that you've got an heirloom from your father that relates to one of the stories. You're getting on in years and you're thinking, you know, it's probably time to pass this on to the next generation. And your daughter's the only one who's ever really expressed interest in your father's life. So the logical choice is to give it to her because she's going to take care of it. She's going to cherish it and make sure that that legacy is carried on. So that's what you do, right? Makes total sense. Until Richard finds out and he explodes and he starts telling you things like you have no right to be giving her that. And she has no right to be accepting that from you. And you start second guessing yourself thinking, have I done something wrong? Have I done something illegal? So you tell Richard, hey, I'm going to go to an estate planning attorney. I'm going to check to see if I can do this. I'm going to make sure that everything's square and that everything's fair for the kids. And that's when Richard drops his next little, you know, whatever you want to call it on you. He says, hey, don't go to lawyers. Lawyers just lie. Just leave it to me. I'll take care of it. I'm going to make sure that everybody gets a fair shake. And that's when he starts going through your house, inventorying everything that you own. And then he sends out these demand letters, you find out, to all of his siblings. And he says, hey, you need to give me a full, complete accounting of anything mom and dad has ever given you. And I'm going to use that info plus my inventory of what they have to determine what everyone gets when mom and dad die, and it will be fair. I'm not kidding. I did not make this up. Now, Richard's your son, okay? And outside of these weird episodes here, he's a pretty stand-up guy, you know, and you love him. But are you really going to leave your estate in his hands? Do you really think that your other kids are going to get a fair shake with Richard in the driver's seat there? So you've got a choice. Okay, you can either leave it to Richard like he wants, or you can put together a plan that's going to make sure the estate's controlled by your wishes, not Richard's. All right, reason number 2, we're going to move on. We're going to start talking about Derek. Now, Derek is your youngest son. He's a very different animal. He still lives at home with you. Now, he's turning 41 this year. He comes and goes as he pleases. He doesn't pay any rent. He doesn't have a steady job or even a steady girlfriend for that matter. But you know what he does have? He's got a dog, and you get to take care of that. It's great, right? Now, you tell yourself that at least you've got this built-in house sitter for any time you go on vacation. But you also find that you still have to call the neighbors and ask them to take the cans out to the curb when it's garbage day, because odds are Derek's not going to remember to do that. Now, you've also been telling yourself that Derek's only going to be living with you until he finds his feet, till he figures his path out. But the years have been going by, and it seems like he doesn't have any interest in giving up that free room, the free food, the free laundry service. And then, to top it off, last week, your youngest daughter gives you a call. She's pretty upset. She's a little miffed. She had a conversation with Derek, and during this conversation, he was talking about your house as if it's his, as if he fully expects to inherit the house when you guys die, because after all, he's put a lot of time in over the years, taking care of you, living with you, taking care of the house. So it would only be fair for him to get the house. Now, of course, you love Derek, but are you really going to leave your house to him? Just hand it to him, drop it in his lap. What's he going to do with it? Can you really trust him to support himself when you're gone? Or are you going to create an estate plan that's fair to Derek and his siblings? One that's actually going to have some incentives in it to get Derek on his feet, get him doing stuff, instead of just giving him an opportunity to burn through his inheritance with his current lifestyle. Now, reason number 3, we're going to call her Kim. Kim is your husband's new wife, and she seems nice enough, but some of your friends have been talking and they feel that they got married a little too soon after you passed away. Kim also has several kids from a previous marriage. So what's going to happen when your husband dies? Do you think Kim's going to be fair and leave your estate to your kids? Are you going to blindly trust whoever your husband marries when you die? No, I mean, certainly you can leave your estate to your spouse because you love them. But remember, once you're gone, there's really no telling what kind of influences will come into your spouse's life to change how your estate's going to play out. These types of influences are out there. It's just reality, but you have a choice. You can confront that reality with some proper planning, or you can leave it to chance and hope that it works out. So if this pushes you guys to want to set up a plan, let's take a look at some, I would say, some common estate planning mistakes that people will often make once they start trying to make the plan, right? So it's good that you're thinking about it. It's good that you're moving forward, but here's some pitfalls to steer clear of. Now, the first one is just not doing it, right? I've heard people say that they don't have anything to worry about. They don't need to do anything. There's still plenty of time left. It's just going to work out fine. And I know someone just like this. We're going to call her Vicky, and bless her, but Vicky's very much a product of the 1960s. And to this day, she still lives her life by the hippie values of, whatever happens, happens, and things are going to work out because they have to. It's incredibly frustrating to watch sometimes. This is also one of the worst ways to plan your estate, because if Vicky doesn't change things, Vicky's estate is going to be decided by the government, by the state laws of the state where she lives. Now, usually the state hands everything to the spouse, but in this case, Vicky is divorced, so it gets a little more complicated. She does have 2 daughters, right? But here's the wrinkle. Her oldest daughter refuses to talk to her. She's estranged, right? They don't get along at all. Her youngest daughter, on the other hand, is stuck by Vicky through thick and thin, even though she arguably has much greater cause to cut Vicky out of her life than her sister does. The state's not going to care, though. If Vicky dies, they're just going to divide everything equally between the 2 daughters. Do you think that's really what Vicky wants? Well, the youngest daughter could try to fight it, but she'd end up having to bring a lawsuit, and then no one wins except for the lawyers. Now, the second mistake that I see people making with their estate plan is when they try to do it on the cheap. They try to use things like owning everything as community property or joint tenants with rights of survivorship, those sorts of things. Because technically, if you own something under that method, when you die, it does go to the surviving spouse. It's automatic, right? The court doesn't get involved. So that sounds nice. But here's the problem. It doesn't take into account any of these issues that we've been talking about. There are no protections for your kids or for future generations. Think about all the hard work that you're doing now to build up your legacy. How you pass that legacy on is just as important as what you're passing on. So you can either choose to finish this race that we call life in stride with proper planning, or you can risk tripping up at the finish line by trying to get cheap on your planning. Now, the third mistake is setting up a will as your estate plan. And this one's particularly dangerous because people who set up wills, they get this false sense of security, thinking that they've done it right. But wills have a lot of hidden costs, and they're not just costs in terms of money. They can actually cause a lot of hardship and resentment in families. So let's think back to that first problem, right? Richard, our oldest son, the guy who thinks he knows how our estate should work. Well, let's imagine that you create a will to control your estate. And naturally, you name Richard as your executor. He's your oldest kid. Most people do that. And normally there wouldn't be anything wrong with that. But in this particular case, how do you think your children are going to fare with Richard as the executor of your will? If he deviates from the instructions you put in your will, and he will, because he thinks he knows better than you, your other kids can only stop him by filing a lawsuit. Imagine the kind of rift that's going to create in your family. Now, this is a situation that is going to tear your family apart, and everyone's going to lose except for the lawyers again. Now, speaking of lawyers, I did mention earlier, right, that lawyers have this financial incentive to encourage people to create wills for their estate plan. And here's why. When you die and all you've done is set up a will, your family's going to have to take that will through probate court before they can get any of their inheritance. Now, probate is incredibly complex and expensive. It's the court getting involved in your estate, and nothing the court does is easy or cheap. Your family is not going to be able to navigate that by themselves. So guess who your family's going to have to hire to help them get through that probate? A lawyer, right? And that's why lawyers put their contact information in the wills they draft. The family's going to read through your will, get overwhelmed, see the attorney's info, and then reach out to that lawyer to help them through probate. Basically a loss leader, if you think about it, and free advertising built into that product. So maybe the lawyer takes a bit of a loss up front, makes a little bit less money if they sell you on a will instead of a proper plan, but they're going to make up for it in spades on the back end when they help your family through probate. A recent study by the AARP found that the average probate cost was about 20% of the estate's value, especially for smaller estates. And by smaller estates, I'm talking below those estate tax thresholds, right? So it's not small in kind of the traditional sense. It's just you don't have to worry about the tax above that 13 or 26 million that you've got. You're still looking at a cost of 20% for this probate. That's a full fifth of whatever it is you're trying to pass on to your family that never makes it to them, gets diverted to that attorney. Now, one of my mentors is an incredible estate planning attorney, and he's had a huge impact on my professional life. And I'd say that he's probably the single biggest influence that led me to become a lawyer and practice in estate planning. And way back before law school, he let me shadow his work and sit in on some client consults with him. And I still remember vividly this one consult that he had with this nice old lady, right? She'd come in, she wanted to set up a plan. Now, he was recommending putting something proper together that would give her these protections, give her these benefits that we've been talking about, but she was hesitant, right? It was a bit more of an investment. She wanted to go with the will. She was very financially careful, all right? She had quite an estate built up because she was financially careful. And initially, she was looking at this choice in terms of the cost that she was seeing up front. He had gone through all the benefits of the proper plan, all the shortcomings, all the pitfalls of the will, but she was still hesitant. So he changed his approach a little bit, and he started talking about the ultimate cost difference between a will and a proper plan. Now, proper plans, they are more of an investment. He conceded that. But wills end up costing an estate far more in the long run due to all of the court and hourly attorney's fees that the will is going to rack up as it goes through probate. And then got a little bit more colorful with her. And he said, "Did you happen to see that brand new Lexus in the parking lot on your way into the building?" He explained that he had just bought that after wrapping up a probate for another family. Now, he didn't set up that individual's will because he just doesn't believe that wills are a good option for clients. But because that individual did die with a will, it needed to go through probate, and the family approached him for help. Now, he is an excellent attorney. He's really good at what he does. It was not a tough probate. It wasn't complicated. Nobody was fighting. Very simple stuff. And he's good at getting probates through the court. But because of the way probate works, it still took several court hearings over more than a year to wrap this estate up. Lots of billable hours for him. He then explained that after he wrapped that probate up and he deposited his check from the estate for those fees, he got to go straight to the Lexus dealer, and he bought that Lexus for cash. So he summed it up by telling the little old lady, "Hey, this is why I tell clients to avoid wills. Wills are great for probate lawyers. They're not great for clients or their families." So she could either save a little money now, so her estate could pay tens of thousands in hourly fees to a probate lawyer, so that lawyer could go buy a brand new car when she dies, or she can invest in the proper plan and be done with it. No more expenses, no more nonsense, no surprises. That value of the car stays in the estate and goes to the family, not the lawyer. Now, after he explained that, she saw the value in what he was saying, of course, and ended up going with the proper plan. Now, in my 8 years of doing this stuff, I've seen people take several paths with their plans. I've seen people who just choose not to do anything. I've seen people who try to do it cheap by relying on community property, joint tenancy, those sorts of things. And then I've seen people who go down the path of using a will to save money in the short term. I've seen where these paths end up after the person has passed. where the family ends up with all of those problems that were kicked down the road. Now, if you're one of those folks that says, hey, I'm not going to care about this stuff, I'm going to be dead, nothing's going to be bothering me at that point, then I'm happy for you, right? It's great that you can live life in the moment like that. For the rest of us who do worry about what we're leaving behind for our families, is it going to be something good? Is it going to be something bad? These issues can really stop you in your tracks. And a lot of people get so stressed and worried about this stuff, they just get overwhelmed and they can't see a way to square with it, so they put it off. If you're in that boat, don't stress. This other path forward that I'm going to teach you now is going to make you feel much better about this stuff. And it's going to help you make a better plan for your legacy, both for you and your family. Now, this other path forward for protecting your legacy, for protecting you and your family, everything that you've been building, is setting up a living trust. Now, a living trust is kind of like a big suitcase. You can pack everything that you own into the suitcase, and it makes it easy to hand it off to the next generation. The key, though, is that you pack the suitcase while you're alive, so everything is moved in there before you die. And because of that, you avoid probate. So let's take your house, for example. You can set up your trust. You can put your house into it while you're still alive. When you pass away, the trust continues to own that house, and it can transfer the house to your beneficiaries without going through probate. It avoids the entire mess. Any asset that's still in your name when you die must go through probate, but any asset that's in your trust's name when you die completely avoids it. So this benefit alone makes the trust worth it. Your estate and your family avoids all the delays, the court fees, those hourly attorney's fees, and of course, the frustration of having the court involved in your personal affairs. So at the end of the day, more of what you got gets to your heirs, and it gets to them much, much easier. Now, as great as that is, that's only one benefit of having a trust. The biggest benefit of the trust, though, is the control that it gives you over your legacy. It's like that suitcase has combination locks on it. People only have access to the trust on your terms. It gives you the opportunity to decide how things will play out and to ensure that your values will continue on for generations. Now, think about these values that you're currently living by. Imagine if you could make that part of your legacy. As investors, we know how valuable hard work, sacrifice, delayed gratification, all of that stuff can really be life-changing, especially for those of us who weren't born into wealth. We also want our kids to learn and follow these values too, because we know that there are always going to be opportunities out there for people who are willing to work hard and sacrifice. Now, of course, we should be trying our best to teach our kids these values while we're alive. But what happens when we die? We can't take everything with us, right? We don't see hearses hauling U-Haul trailers with them to the cemetery. The stuff has to go somewhere. It can't go with us. And for most of us, we want our stuff going to our kids. But do we just drop everything into their laps? Like, what's that going to do to them? Is that going to reinforce those values of hard work and delayed gratification if they suddenly have a boatload of assets just sitting in their laps? So what do we do? Well, my wife and I had the same question. We had a choice that we had to make. We had to either go with a will, which was cheaper and pretty attractive because of that at the time, or we could go with a trust. We didn't want to just hand a child their entire inheritance, and say, don't spend it all in one place and hope they listen. Heaven forbid we pass away while they're still young. The trust is more of an investment, but we went with the trust because it gave us the peace of mind that we're looking for. Our trust is actually going to hold on to our child's inheritance, all of our children's inheritance. It's going to keep it all protected, invested, and productive. And as those assets are generating income inside of the trust has the option to make distributions to the children, to take care of them, and to take care of important things like providing them with education. The trust can also be flexible enough to either count things like traditional college education as an authorized distribution, or trade school or military service. We don't want to pigeonhole our kids. We want to incentivize them to be productive members of society, whatever that may look like for them. And since they're still pretty young, they're still figuring out what they want to do. So we don't want to, dictate terms on you have to go to this school or go through this career or what have you. Although you could do that if you wanted. For us, though, we like that flexibility for them. The other thing that we're doing with our trust is we're using it as a bit of a carrot to incentivize them to work hard. We have provisions in there that will match their income. So if they choose to kind of skate through life, get a part-time job, make 20K a year, the trust will match that. Here's another 20K. But then they kind of have this carrot dangling in front of them where they think, if I work a bit harder, go into a better career, better field, get a better job, and I make something more like 100K, the trust is going to match that too. So there's that nice incentive. Now, on the other hand, raising kids is no part-time job, and we don't want to disincentivize our girls if they decide that they want to be stay-at-home moms. We're not going to punish them for that. So we've got provisions in the trust to cover that scenario too. And then it could also be something like going into a field that maybe doesn't pay much, but is still really important. So if they get into charitable work or public service, like they become a firefighter or a police officer, something like that, we don't want to make them feel that they have to choose between this nice calling that they feel that they're being called to or money. The trust is there to give them opportunities and incentives and give them flexibility to live a good life. So at the end of the day, my wife and I, we don't want our investments to just evaporate when we die. So we chose this trust and we put it together in a way that it's going to keep those investments productive. It's going to hang on to them, and it's going to create income for our kids with incentives, with opportunities for them, and maybe even for their children, depending on how those investments play out. So remember when I said earlier, right, that the living trust is this other path forward that we can take, one that removes worries and stress about your legacy. You can see that now, right? But hang on, it actually gets better. Let's talk about a few more scenarios that often bother people and people get really worked up about. So let's say, maybe you're worried that your estate is going to have quite a few problems because you have a blended family. Maybe you and your spouse both have children from previous marriages. Have you guys worked out how your estate's going to play out? Of course, you can leave everything to your spouse, but then you have to wrestle with what happens when they pass away. Are your kids going to get a fair shake? Now, that's a tough knot to tease out, but not if you have a trust. You can have your trust divide your estate into two portions. Now, one portion will go straight to your surviving spouse when you die, and they can leave that portion to their kids when they die. The other portion is going to stay back in the trust. That income from that portion can be used to take care of your spouse while they're still alive, so they don't have to give up their standard of living or anything like that. But when they die, this portion you held back, that goes to your kids. So now you can make sure that your spouse is fully supported, but the kids from both marriages are protected. You're removing the opportunity for someone to get cut out of the estate against your wishes with proper planning. Now, you can also do something really similar to this if you're worried about your spouse getting remarried after you pass, and you're worried that there might be some influences that come into your spouse's life after you're gone to take advantage of this situation. And a similar setup is going to protect your kids from having their inheritance diverted to someone trying to do that, someone trying to take advantage of your spouse. So maybe if they're getting on in years, maybe they're not fully with it, you don't have to worry about someone coming in there and having these nefarious motives to cheat your kids out of their estate, out of their inheritance. So again, with this kind of planning, you're not saying, I don't trust my spouse, as far as I can throw them. No, you love your spouse. You do trust them. You don't trust these other influences that are out there. And with a trust, you can put some guardrails in place to keep those influences out of the estate. Now, maybe you're actually worried not so much about you or your spouse, but more about your kids. What if one of your kids gets into this nasty divorce, or maybe they get into some legal troubles of their own and they have this really aggressive lawsuit creditor coming after them? The trust can actually be built to protect their inheritance from the claims of their divorcing spouse or these other legal creditors that may come their way. It's called a spendthrift provision. And it's definitely something that you want built into your trust to protect your beneficiaries. It gives your trustee authority to hold back the inheritance if someone's going to try to take it from your child. The trustee can still make payments on behalf of the child, to take care of them. So if they end up in the hospital or something like that, hospital bills can be paid. But because it goes around the kid, the creditor can't take it. The divorcing spouse can't take it. It's kept in the trust, it's kept invested, it's kept productive, and then payments can be made on behalf of the kid until that creditor goes away. So it basically keeps your legacy from getting hijacked and diverted somewhere that you don't want it to go. So, that's just some information on living trusts. And with that information, by now you guys realize that putting together a proper plan for your legacy doesn't need to feed into fear or anxiety. Taking the right steps to get some proper planning in place will actually break you out of that cycle of fear and anxiety. And by now, you guys realize that this is an important thing to do that will also bring you peace of mind. And you can see that, the better we understand these benefits, the better we're going to be able to do for our estates and for our families. And if you like this, if these trust benefits sound like a good fit to you, you're also going to want to pay attention to the next slide here, because now we're going to get in and talk about some other documents that help the trust do its job right. Other important parts of a proper plan that can give you even more peace of mind on top of what the trust is doing for you regarding your legacy. So a proper plan really is kind of like a puzzle, and the trust is just one piece. Now, it is the most important piece, and it does a lot of the heavy lifting, but you can set up these additional documents to back up your trust, to really empower it to do its job right. Now, the first document is a will, and I know some of you guys are looking at me thinking, hey, you just said the trust is better than the will, and you shouldn't use a will. This isn't a normal will. Don't worry. This is called a pour over will because its job is to pour assets into your trust. Normally, once you've got your trust, the next step is putting your property into it. It's called funding the trust. And this is critical because anything you want the trust to control needs to be owned by the trust. Sometimes life gets in the way though, and you might miss something. You might pass away with your house still in your name. Normally, that would require a long drawn out probate, where the judge needs to get involved, needs to examine the estate, determine the potential heirs, decide who gets the house, and the judge might not get it right. With a pour over will, though, you can avoid the issue. The will tells the judge, hey, my only heir is this trust. So anything that's still in my name when I'm dead, just put it in the trust. The trust is going to take it from there. You don't need to be involved any further. So it's kind of like a safety net, you could say, and it ensures that the trust is going to control everything that you have, even if it doesn't quite make it into the trust before you die. Now, the second document here is the financial power of attorney. This lets you pick another person and give them authority on your behalf to make financial decisions for you. That could be paying your bills, taking care of your financial obligations, managing your business, your legal affairs, all of that good stuff, if you ever can't make those decisions for yourself. So if you're hospitalized, if you get dementia, something like that, your financial power of attorney can jump in and make sure that everything is kept nice and tidy. Now, besides that, why would you want this document? Well, let's say you are incapacitated. Maybe you're hospitalized and things are kind of touch and go and your family's not sure what's going to happen. Well, if you named your daughter as your successor trustee, she's going to be running the trust for you now. But let's say she's going through your documents and she finds a bank statement for a bank account that's still in your name. It's not in the trust. If you die, they're going to have to use the pour over will and do a little probate to get it into the trust. So if she goes and she tries to fix that by moving this account into the trust, the bank's going to say, hey, you don't have authority here. As a trustee, you can do whatever you want according to the trust instructions with the property in the trust, but that's where your authority stops. You're not your father. You can't touch his account. But if you've made your daughter your financial power of attorney, now she does have that authority. She can move the account into the trust and the trust can take it from there, and they avoid even needing to use the pour over will altogether. So this is a great fix for situations where you can't make decisions for yourself and you happen to forget to put something in the trust. It makes the trust even more forgiving. Now, the third document is a medical power of attorney. This is kind of like the financial power of attorney, but it's specific for healthcare decisions. So you get to pick another person and give them authority to make those decisions when you can't make them for yourself. So let's say you're on life support, right? Or a persistent vegetative state is what they call it. Well, this person can jump in. They can determine your medications, your procedures. They can give and withhold consent on your behalf. So you've got someone that you trust, that you know, advocating for you, serving as a sort of a check and balance on healthcare providers, making sure that they're keeping your best interests at heart. Now, fourth is a living will, and this one is kind of similar. It comes into play in that same scenario where you might be in a persistent vegetative state. You might be on life support. This living will lets you get really specific about your end of life wishes and what you want done if you ever are in that situation. And you can say to your family, hey, I don't want to be kept alive as long as possible. If I'm clearly dying, keep me comfortable, keep me hydrated, but let me go. I don't want to be turned into an ATM machine for the hospital. I don't want the hospital bill to be run up and have even more of the estate eaten up before I can pass it on to you guys. So you can take the burden of making that kind of heavy decision off of your family and preserve more of your legacy for them. Now, the fifth one, this is a HIPAA declaration, and HIPAA is that federal law that basically prevents people from sharing your private medical records, but sometimes they take it to the extreme. And you'd think if you named a medical power of attorney to make healthcare decisions for you, they'd also be able to look at your medical records so they can make informed decisions. But sometimes people can be a little unreasonable in this area. They might stonewall your family if it's not clearly laid out for them. So that's what this document does. It lets you say, hey, my medical power of attorney, they can see my medical records. Don't stonewall them. Let them make informed decisions. And that takes care of that issue for them. Now, the last one here is your final instructions. And this one lets everyone know how you want to be remembered, right? So if you've got anything in particular that you want to dictate regarding your final service, it takes the burden off of your family from having to make those kinds of decisions while they're grieving. So it's another kind way to make things easier for your family when you die. Now, these are the big 6 documents that you want to have backing up your trust, but it's not an exclusive list. There are some other documents out there that we think are important. I'm going to share this last one with you because people really like this one because it can prevent a lot of drama. It can prevent people from getting squirrely. It's called a schedule of gifts, or some people call it a personal property memorandum. It's kind of the fancier name for it, but the schedule of gifts is important because we've seen grown adults fight over plastic toys because of the sentimental value that they've given these plastic toys. People don't think right when they're grieving a loss, and these little sentimental things can really stir up a lot of trouble. Now, you can work all of those conflicts out while you're still alive using a schedule of gifts that lays out who gets what sentimental item. You don't want to push this stuff off until you're not there to mediate anymore, because for whatever reason, this seems to be the spark that sets off the drama. If you remember back to Richard, right, when he found out that his youngest sister got that sentimental item, it all went to heck after that. So you can use the schedule of gifts, as leverage, because you can actually change whatever you want, whenever you want, anytime someone's not behaving themselves. So if someone's not being nice or they're not showing up to Thanksgiving like they're supposed to, you can just line item that, and it acts kind of like a carrot and a stick to make sure everybody plays nice while you're still alive and after you die. All right, now obviously this is a lot of documents, a lot of considerations, but these are important documents. And it can be a little overwhelming to think about having to get all of this done. But by now, we also all know how important it is to have this planning in place. And I know a lot of you guys are probably saying to yourselves, I want to do something right now. I want to be able to have a plan for my family, and I want to do it right. And because this is such a common feeling, and so many people have this interest in having this proper plan in place, we've actually put together an easy package for you for being here with us today so you can find that peace of mind. Now, we're offering a complete, customized legacy package. The core of that package is the custom drafted living trust, just like the ones that we've been talking about today. This is going to be a trust that will be ready for life surprises, one that's going to protect your kids if your spouse gets remarried, or if your kids get into legal trouble, or they go through a divorce of their own, so they're not going to have their inheritance taken from them. It's going to be a trust that will protect your legacy from attorney's fees so that more money goes to your kids and doesn't get diverted into the attorney's pocket. And it's going to be a trust that preserves your values as a part of your legacy. I've spoken with other people who've worked with other firms to get a trust just like this in place. And they've told me that they've paid $9,000, sometimes more, just to get this kind of trust in place. And that's really not uncommon, believe it or not. A solid trust, like the ones that we draft, will easily be 85 to 90 pages long or longer because of all of the custom language that we draft into these things to cover all of these contingencies, just like protecting your kids from their divorcing spouses and everything else we've been talking about. So there's really a lot of value in a trust like this. Now, to complete this legacy package, it's not just the trust. We're also going to include that pour over will, which makes sure that your trust will control and protect your entire legacy, even if you miss putting something into the trust. And a will like this typically costs $1,500. We're also going to include the financial and the medical powers of attorney, which give you that peace of mind to know that you've got someone you trust advocating for you if you ever can't take care of yourself, keeping things nice and clean, keeping things from turning into a problem. And those can typically cost $1,000 each. We're also going to provide the living will, which takes that burden of end-of-life decisions off of your family, the HIPAA declaration, which helps your family get around that red tape that can sometimes pop up with your medical information. And we're going to throw in the final instructions. And that lets your loved ones know what your final wishes are as far as how you want to be remembered. It gives them that guidance. And these three each by themselves can set you back $500 typically. But besides these, we're also going to include that schedule of gifts that I talked about, along with some other important documents to make sure that you really have this complete, proper plan in place for you and your family. And by now, you guys know how important it is to get these documents right. These are not going to be one-size-fits-all documents like what you'll find on the internet. What we do here at Anderson is truly unique. You'll be able to set up time with one of our experts, one of our estate planning attorneys, and they're going to sit down with you one-on-one and go through your exact situation. So we know exactly where you are, exactly where you want to be, and exactly how we can get you there. And then you'll be able to take advantage of these resources that we've built here at Anderson for almost 25 years to help our clients. And then you're going to know that this plan was designed personally for your situation. Now, with all of the value built into a package like this, if you add all this up, normally this would require an investment of $14,000. And with everything a package like this provides, protecting your heirs' inheritance from divorce, from their other creditors, from all these other issues we've been talking about, avoiding the legal fees, making sure more of your money gets to your heirs, and empowering you to pass down your values that you care about, $14,000 is actually a great investment. I think that investment makes a lot of sense because of all the trouble this stuff avoids and all of the benefits that it can provide. And that's why a lot of people, there's a lot of people out there who make this kind of investment all the time to protect their legacies, and they think it makes sense too. But when Don approached us about giving this training, he wanted us to provide something that would really help people to be able to get this stuff in place, something that would really help them to get moving and make it easier. So we created a webinar rate for this package. And because you've taken the time to educate yourself as part of this training, and because, we really think this stuff's important and we want to make it accessible for people, we're giving you a significant discount to get you started. Your investment's not going to be $14,000. Instead, it's going to be $3,750, which saves you over $10,000, putting this package for you guys under $4,000 instead of that $14,000. And there's enough value here that really there should only be two reasons why you wouldn't want to make a move on this. Either it's me, I'm the problem, I didn't do a good enough job explaining the benefits and the value of this plan, or you're just not in a position to make that investment right now. And if you're not, I get it. But hopefully I did a good enough job conveying the importance of this stuff and what it can do for you. Now, for those of you who see the value and want help getting their plan in place, getting that plan going, here's what we're going to do. You can use this special link here that's just for the people who attended tonight or who watch or listen to the replay. It's aba.link/protectlt. Now you can also scan that QR code there on your screen. That'll get you to the same place, or you can copy the link into your browser. I'm also going to drop the link into the chat for you guys. But all you got to do is scan that code or use that link. And when you do, it's going to pull this page up where you can input your contact and your billing info and submit it. We're going to be handling those on a first come, first served basis. So as you submit your info, that's the order that we're going to be going in. There's a lot of people out there asking for help with this planning. So as you're putting those in and you fill out that form, you're going to go into a queue. And in that order, we're going to be making welcome calls over the next couple of days to get you started. From that point, you'll be in our system and we'll get you through our process. So it's really simple. Instead of just hearing about it today and getting excited, knowing that there's a solution out there with this proper planning, you can actually start taking the necessary steps to be able to have that solution in your life. Now, thank you guys so much for your time today. It's really been great. If you're the kind of person who sees the value in this proper planning, then make sure you scan that code or use that link to get started. We're excited to spend some time with you and help you get your plan in place. Now, I'm going to leave that code and that link up for you guys while I answer any questions that you've got. So let me take a look here. Or Dawn,
Okay,
did you want to
Jonathan,
narrate?
let me pop back in here.
Sure.
Does life insurance count against your estate? Really
Yes.
good question from Terry.
Yes, it does. So depending on the amount of life insurance that you've got, that's something that you want to take into account, because that total value of the estate really is counting just about everything that you've got.
Yeah, and let me comment on that, because I've seen so many life insurance agents say, look, when people receive money from a life, this is totally tax-free. And although that may be true on income taxes, it is not true with estate taxes. And if you get $1 million or $2 million or $5 million policy, it will be part of your taxable estate, which is a big deal with the estate tax potentially coming down. That's a big deal. And again, insurance companies, agents, I'm not sure that they're trying to lie to you, but they're misinformed if they're telling you that it's totally tax-free, because estate taxes and income taxes are very different things.
Right.
Any comments on that?
Nope, you're exactly right. And that's sometimes what trips people up. We've got the income tax, and that's the big one that we're always thinking about, because that's the one that we feel the most every day. But the estate tax is a bit of a different animal. So the rules are different. So if you've ever got any questions or concerns, you definitely want to seek out some guidance on that from somebody who knows what they're doing, right?
Yeah, and so far, Jonathan's only talked about federal estate taxes. He hasn't talked about state estate taxes. And we'll hit that when we come to the 3-day summit. We'll talk about that, and I'll show you a map of here are the states that tax your inheritance, as opposed to those who tax, the giver, which is the estate tax. And there are states that start at $1 million. It's not a 13. Oregon, for instance, any estate over $1 million, there's an estate tax. So yeah, it's a big deal. Okay. Jeff is asking, please clarify, if I die, my wife gets all transferred to her, but not tax. When she dies, does the estate have a $7 or $15 million or $14 million exemption?
Sure. Yeah. And this is something that you want to have built into your trust. There's something called portability now. Normally, what happens is each spouse gets their exemption, that $7 million exemption. But if you leave things to your spouse, those inter-spouse transfers are tax-free, so they don't use your exemption. So people were finding, shoot, if I give something to my spouse, I'm losing out on the $7 million exemption that I didn't use. Maybe I shouldn't give things to my spouse. So to fix that, Congress actually came out and said, hey, we're going to let you do something called electing portability. It basically means that you can leave everything to your spouse. That's a tax-free transfer when you die. And then as long as your spouse files the right tax forms within 9 months after you die, they can claim your exemption for their own. So then when your spouse dies, they get to leave the double figure. So right now that's 26 million. When it sunsets, it's going to be somewhere around that 14 million, depending on how inflation is at that point.
Okay, so Jonathan, what about a large estate? Let's say a $50 million estate. Is that totally tax-free when the first spouse dies, or is there or are we limited to the 26,000? Or
So
26 million?
it's totally tax-free. The transfers between spouses, you're good to go. And so that does buy you a little bit of extra time, but it's typically best to have your estate tax planning figured out before the first spouse passes, because doing the planning afterwards, there's still some opportunities there, but it's going to be a little bit more limited, especially if they didn't catch that 9-month deadline to elect portability.
Absolutely. Okay.
Hey,
Does an
Don, I wanted to
IRA
throw one in there
for
really fast. It's just a lot of people asking about where to click. I did put that on the chat screen. It is clickable, the second link there. So a lot of people had to leave. So it will be in the link there in the chat screen. Click that. That's taking to the offer. And Jonathan, how good's the offer for?
Sure. So this is for anybody attending this event, anybody listening to the replays, watching the replays. We're gonna keep that one open for you guys.
Awesome. Thank you so much.
Okay.
Yep.
Good. Thank you. Does an IRA or 401 count toward your estate?
Yes, it does. So proceeds from your retirement accounts, those all count towards the value of the estate for estate tax purposes.
Okay, so we have a long question here from Val. My sister and I recently inherited annuity stocks, IRAs, a primary residence, condo, income producing properties from my parents due to death. They had wills and each had a trust. Total estate, probably $3 to $4 million. Now that my sister and I own 50-50 everything, how should we structure? LLCs, separate trusts? I have no children, single, my sister's married, grown kids. Okay, so this is kind of an individual. We don't know what state you're in. We don't know. There's a lot of things we don't know. Jonathan, do you want to take a stab at this?
Sure. Yeah, so just like you said, it's probably gonna have to be a little general here, but as a general rule, and I'm going to be making a few assumptions here, it sounds like you guys have already inherited the property. So it's no longer in your parents' trust. So you've got total control over it at this point. It sounds like some of the property may have come out in kind. So you guys got maybe a deed where you're 50-50 on some property, something like that. So at that point, the first step, I would say you're exactly right here in your question, getting your own trust set up, because your own trust can own all of that stuff, have instructions for all of that stuff. And then that at least takes care of all of these planning issues that we've been talking about while you're working on the asset protection side of things. As far as the asset protection goes, it's really easy to plug into the living trust once you've got it in place. So there's really no reason to wait on the trust. You can get moving on that right now. And then, you can sit down with an asset protection advisor and work through what the asset protection angles should be. But generally speaking, yeah, if you've got investment properties in there, LLCs would be a good fit. If you've got any other kind of investment assets that you want to keep protected, something like, cash, or maybe if you've got some securities in there, something like that, then a Wyoming LLC might be a good fit there too, generally speaking.
Yeah, and there are some assets like income producing properties. Maybe we would put that in an LLC that's owned 50-50 and we continue that in there. It would do, but eventually as your families grow and the kids and the grandkids and I think you're going to want that separated. Eventually, that doesn't necessarily mean now. Is there any reason, Jonathan, to keep things in a trust? I know you can keep a trust alive for up to 25 years, generally after the grantors have passed away. And there's sometimes a reason to keep it in the trust and not immediately disperse it. What are the benefits of maybe keeping some things in the trust?
Sure. Yeah. So the rub will really come down to how that trust is drafted. And let's say it's properly drafted and it's got the features that we would want to see in a trust. So in that scenario, it would have things like spendthrift provisions in there. So if you've got something in there that's kind of valuable and you're looking at maybe a lawsuit coming down the pipeline, you might choose to keep that asset in the trust, because when it's in the trust, it's protected from your creditors until you pull it out. And there's a few other considerations to keep in mind there, because usually by the time that the grantors have passed and it's owned by the beneficiaries and they have the choice to take it out or keep it in, there's also some tax planning issues that you need to worry about, because the trust and estates tax rates can be quite a bit higher if they're not kicking things out to the beneficiaries. So it's a bit of a balance, but that could be one reason. There's actually some nice asset protection benefits that your beneficiaries could take advantage of if they find themselves in a tough spot and they haven't pulled things out of the trust yet. So it can be kind of a nice kind of backup asset protection plan. Another one might be if you've got a dynasty trust that your parents set up. And dynasty trusts are a little bit more advanced. It is something that we set up, and it's something that we could create as a part of this package that I was talking about. But it's essentially a trust that's designed to hang on to the assets more or less permanently, using them to generate income that they then kick out to the beneficiaries. And if the beneficiaries know what's good for them, they're going to leave it in the trust so the trust can keep making that income, keep those the principal assets protected, and then they just get this mailbox money from the trust each month. And then that mailbox money gets passed on to their kids when they die. So dynasty trusts are a fun one. If that sounds like something that might be a good fit for you, you'll definitely want to bring that up when you have your one-on-one with the attorney.
One of the reasons my mother passed away, I think it's 13, 14 years ago, we've left her house in the trust. And mainly because if we pulled it out, there's going to be a property tax reevaluation. And we've just left it in the trust. There was no reason to pull it out at this point. So, okay, so many more questions. Could you explain what happens after the 5-year Medicaid look-back rule ends? Is the client free and clear from the estate looking in?
Yes. So generally speaking, it's a 5-year look-back period. And if you happen to time it right, then yes, the clawback doesn't apply anymore. Now, here's the thing. These Medicaid trusts, these are irrevocable trusts. They're those one-way street trusts that I was talking about earlier in the presentation. And they're really tricky because if you don't get the timing perfect, you end up needing Medicaid before the 5-year period's up. It's like you never did anything at all. Or if you set up the trust and it ends up taking 10 years before you end up needing Medicaid, then you needlessly made yourself basically poverty stricken for an additional 5 years beyond what you needed to do. So these trusts you want to be really careful with. They're a real roll of the dice. So if that's something that you're looking into, this irrevocable Medicaid trust planning, be extremely careful with that.
Okay, good. What happens to money in IRA accounts? So let's say your parents die and leave you with an inherited IRA. What happens to that? But the IRA is a trust. And so, Jonathan, tell them a little bit about inherited IRAs.
Sure. Yeah. So inherited IRAs, from a kind of a trust funding perspective, generally speaking, what you'll see is the trust will be the beneficiary on that beneficiary designation of the IRA. And that way, the money in the IRA that goes into the trust, and it just goes into the big pot, and it follows all the same rules of everything else in the trust. So that keeps things nice and simple. With that said, if you've got a spouse, you'll typically want the spouse to be the first beneficiary, the trust as a contingent. And that way, your kids aren't just getting handed the IRA funds and they can do whatever they want with it. The trust is there to kind of meter it just like you want. Now, spouses who inherit IRAs, they've got a little bit more flexibility than children do or any other people who inherit IRAs. So spouses can do things like roll it into their own IRA. They've got a lot more flexibility with planning there. Kids generally, though, you have this clock that starts ticking. You have to start taking out those distributions. And if you don't, they penalize you. So it's one of the more recent changes to that. But as a general rule, if you've got an IRA, typically your spouse is going to be the primary beneficiary because of that flexibility. And then the trust is a backup. So if your spouse isn't around, it's not just getting dumped into your kids' laps.
And I really like what you said about making your revocable trust the contingent beneficiary. And we're going to cover that when you get to the 3-day summit. We're going to show you several examples of how we make a trust a contingent beneficiary of a IRA. So, okay, Agnes, what are the requirements of a trustee? What kind of person makes a good trustee? This is such a good question. Oh, if you make one child trustee, will it cause a rift with the other children? Yes, it can. What other things work well in the trust? Give us some ideas on who should be your trustee. Obviously, the word trustee means something. Tell us about that, Jonathan.
Sure. Yeah. So Agnes here she's thinking about it right? She's thinking about the right questions here. And this is exactly what we talk about in those one-on-ones. So as far as trustees go, there's really only one hard and fast rule. They need to be at least 18. And outside of that, they could basically be anyone that you choose. And the reason for the 18 is, if something happens to you pretty quick after you name them, you want them to be old enough to actually be able to step in so the court doesn't appoint someone else. Now, as long as they're 18, again, could be anyone you want, but that also presents a problem because there's a lot of different options out there. Now, you do want it to be someone that you trust, right? They are in charge of the trust. They are legally bound to follow its instructions. But if they decide to get squirrely, the court can still step in, pull them out, and put somebody else in. So there are some safety valves built in. Now, as far as picking your trustee goes, beyond someone that you trust, most people will pick a child. Often it's an oldest. Sometimes it's not, though. Sometimes the oldest isn't the most responsible kid. So there's really a few different ways that you can approach that, just depending on your preferences and your family circumstances. If all of your kids are underage, then often people will pick another relative, maybe one of the kids' grandparents or an uncle or a close family friend who's familiar with the family and understands your goals and is going to be able to interpret your trust instructions according to your wishes. You can also have contingent successor trustees listed. So let's say you do name your oldest and your oldest happens to either not be available, maybe they're just totally out of the country and unreachable, maybe they're incapacitated or they've passed. You can have other people listed to serve in succession. And then depending on the circumstances, you might even have co-trustees, where let's say you've got two kids and you're worried that if you name one, it's going to cause problems with the other. You could name them together. Now, that does mean they're going to have to work together because they basically have a veto on each other's decisions, but maybe that's what you want for those kids. Maybe you want them to have to be unanimous before they do anything with the trust. So there's really quite a few options there, and it really just does depend on your personal circumstances.
What I've done in my trust is I've got 5 kids. In Utah, we have to say just 5, but okay, so it was 5 kids, and I've made 2 of the kids co-trustees. They're the closest, they're the most responsible. Those 2 have to agree before anything is distributed, and we've found that works fairly well for, at least we think it will for us. A trust, can it last for 100 years? There's a rule of perpetuities. How long can a trust generally go?
Yeah. So it depends on the state. Just like you said, though, there's this really old rule out of Old English common law called the rule against perpetuities. It essentially means that the trust can last somewhere around 120 years. It's a little more complicated than that, but that's kind of the general rule. And for states that have kept that rule around, it's kind of a vestige of law that doesn't really need to be around anymore, but for whatever reason, they still have it. Then you're typically looking at that. Now, when we set trusts up, we're generally going to set them up under the laws of Nevada, because Nevada has opted for a different rule against perpetuities. They'll actually let your trust last 365 years. So if you want to do the dynasty stuff, you can really make it last. You can even put a provision in there that allows for that trust to pour into a new trust if it ever expires. So it can just keep going down the ages. So you can get really, really creative with this stuff.
Okay, we've got more questions than we do time, so let's go a little bit faster. What are the implications of a foreign inheritance? How does estate planning work for foreign assets and foreign inheritances?
Well, that one is really fact specific. It's going to depend on what country you're dealing with and the tax treaties that the U.S. has with that country. Some countries have some pretty good tax treaties where it's not going to impact you on the estate tax in the U.S., but it does impact you in the original country. So that's one where you'd have to get with somebody who specializes in that cross-border taxation to really get a firm idea on your particular situation.
Cindy is asking, do you offer a payment plan? If she's interested in doing your trust deal, do you offer a payment plan?
We don't currently, but if you can't do it now, no worries. We're still happy to have you. And as far as I know, this one's going to be open for a little while. So if that changes, you can still jump on it. But we also have a lot of content just like this that's free and available. So even if it's not right for you right now, don't go away. Feel free to keep checking us out, keep looking at our free content and getting that education for yourself.
And Cindy, this is being recorded, and it will be available on our YouTube channel. And Anderson also takes credit cards. And you do payment plan that way. So I don't know. Anyway, if you want to get started, do you offer a free consultation?
Yes. So we do have scenarios where we could have like a free strategy session. If you go to some of our live events, we'll have that as an offer. Tonight's offer is the trust itself, though, and that involves the consultation to go through it. And with that said, we also firmly believe here at Anderson of doing right by the client. So if we sit down with you in that one-on-one and we find out, this isn't really right for you, we don't have any problems refunding, and no hard feelings. You can still stick around. You can still use this for other things. But we're not just going to, take the money and run and set you up with something that isn't going to help you.
And Anderson is very, very good about that. If they meet with you, let's say you pay for it in full tonight and they meet with you and this isn't going to work for you for some, I don't know, whatever reason. Anderson is really good to work with. And because they're on our stage, Protect Wealth also stands behind that as well. So, okay, Robert, if a married couple, do you have a single trust for both? Or that's a good question. Sometimes even in a married couple, you're going to have two separate trusts. Sometimes you're going to do a marital trust. How do you decide which way to do this?
Sure. Yeah, that's a great question. And that's something that we would tease out in that one-on-one session with the attorney. But as a general rule, it depends on the state that you're in, and it depends on, generally speaking, how much separate property each of the spouses have. If you guys have a little bit of separate property, but most of it's marital or community property, most of what you guys have built up since you've been married, then a joint trust just makes the most sense. It's going to be the simplest path forward, and it's going to allow both of you to use that same trust to dictate your terms as far as where your property goes. Your half of the marital and you're separate, and then your spouse's half and they're separate. But we do see scenarios where people are coming to the marriage, maybe it's their second or third marriage, something like that, with a lot of separate property. And they may even have prenuptial agreements in place. In that scenario, then typically the spouses will have individual trusts. And that way they can dictate where their assets go and the other spouse isn't involved. It keeps everything separate, keeps it from getting commingled and from violating that premarital or that prenuptial property agreement that they might have.
Or if one of the spouses has had tax problems or is in litigation, we might very well set up two trusts. And there's sometimes a reason for that. But yeah, I think it's really good advice. Thank you. Okay. Anonymous. As Anderson does estate planning, reduces taxes, asset protection. If a family requires additional LLCs for asset protection, how does that work with estate planning? Should you create a trust, put everything in? When your affairs in order, do you do the LLCs first and then tie it into the trust, or do you set up the trust first? And I think you can do it either way, but what's your preference?
Sure. Yeah. So my preference is, if you absolutely have to pick just one, get the trust in place, because that acts like the foundation for everything else. And you can form things with the trust as the owner from the beginning if you want. You might not. It's still really easy to put things into the trust afterwards. But getting the trust in place takes care of so many issues and so many unknowns, and really protects your family after you're gone. The LLCs, that stuff protects it while you're still here. So there's still value there. But sometimes people will get the LLCs and then think, oh, I can put the trust off. And that's why the trust typically gets left off, and families can end up in a big mess. So I'd say if you're really choosing between one or the other, get the one that people typically forget about and end up really regretting, or at least their family really regretting that they forgot about it. Now, the trusts that we form are really flexible, though. So you can do it whichever way you want. If you've got a few LLCs, you can set up the trust, move the LLCs in, make more LLCs in the name of the trust in the future, whatever you want. Once the trust is set up, you don't have to change the trust to accommodate new assets. It's really flexible. As long as the instructions in the trust still match with what you want, they'll apply to whatever you put in there from that point on.
Yeah, and I look at every situation very differently. If their major concern is right now, I've got to get my taxes out, great. Then we set up the corporation first. If I've got rental properties and I have a threat, let's set up the LLCs first. But if everything is perfect and we're in calm waters, which of course that's never the case, but in a perfect scenario, we always set up the trust first, because when we go to set up the corporation, we want the stock certificates titled in the name of the trust. We want the LLC. Maybe the members are the trust and we tie everything in that way. And again, we're going to spend a lot of time between Clint and I at the next 3-day summit teaching you how to tie it in. But if we're in calm waters in a perfect world, which again, we never are, but we set up the foundation first. Is that fair?
Right, exactly.
Okay. What if your spouse, or what if your spouse is what I do? Oh, wow, I'm confused. Maybe you better take a stab at that one.
Yeah. So I think it's what if your spouse is, what do I care if I'm dead? Kind of a mentality. Is it worth doing if you've got?
Okay, yeah, there we go.
Yeah, I mean, it's funny. I actually talked to quite a few couples where it's clear that there's one couple who's really invested and understands the value and the concerns and the problems that this is going to avoid. And then you'll get the other one who's just kind of there because maybe they have their ear pulled or their arm twisted. But by the end of those consults, both of them are fully participating, because it really opens the eyes of that other individual and goes, oh man, yeah, I need to get this taken care of. I've been a little too blasé about this stuff. And if I get this done and get it done right, I can go right back to not having to worry about it anymore.
Yeah, and your estate plan is going to reflect your values. And if I'm estranged from my kids and I don't care if they fight and here's the assets, you fight all you want. If those are your values, don't do an estate plan. But if you want your kids to get together at Christmas time and Thanksgiving and talk and family weddings and not be fighting over nitpicky stuff, and it's, I don't know, I really think your estate plan reflects your values. But maybe if that's your values, I heard if life insurance is held in a special way, it's not it's not part of your estate, and that would be true if you used irrevocable life insurance trusts, right?
Right, exactly. So ILITs, irrevocable life insurance trusts, they're kind of like a sidekick to your main living trust that we've been talking about. You want to get the main living trust done because that one everybody needs, period. ILITs are part of that kind of irrevocable trust territory where there's so many different flavors out there. None of them are really universally applicable, but in certain circumstances, people do set up these irrevocable life insurance trusts. And that's also something that we could talk to you about in that consult to see if it is a good fit for you. And set up right, just like you said, the payout doesn't get counted as part of your estate. And so people will sometimes use that as a way to pay for estate taxes without using the estate to pay for the estate taxes. And there's a few other things you can do with them too. But yes, set up right, that's exactly the case.
Perfect. What about cryptocurrencies? How do you transfer those to beneficiaries?
Yeah, so this one, there's a lot of different thoughts out there. And I've got some colleagues, some of the other attorneys here that are really into crypto, man. They got a ton invested in Bitcoin, and it's almost all they talk about. It's great. But there's some services out there, interestingly enough, some third-party services out there that you can use to hand your keys off, to hand your wallets off even. So those seem to be the ones that a lot of people are turning to nowadays. You can put some instructions in the trust that say, hey, my digital assets, this person can take care of that. So to whom it may concern, if they present the trust, give them access to the account. Problem is, we've been finding a lot of these places out there don't necessarily listen to that, and they make you go get a court order. So that can be a real pain in the neck. So if you're not going with these third parties that make it easy to hand things off, the other option would be to have somewhere accessible for your trustee the information they need to get into the cryptocurrency and transfer it. And that's a bit of a security risk because whoever has that stuff can use it. So you might have to get creative and use a safe deposit box with instructions in the trust on where that is for when you die. But as a general rule, it seems like these third-party transfer services are a lot cleaner. They do cost a little bit, but it gets rid of all that headaches. And since it's a pretty new area, odds are we're going to be seeing some new developments coming out as people start passing more and more with crypto and these problems start coming to a head. So it's definitely something that we're keeping an eye on, especially because some of my colleagues are heavily invested in this stuff and worried about it themselves.
Okay. Now, let's talk about time for just a minute. Generally, we don't go past 8 o'clock. We're a little bit after. Are you okay, Jonathan, in staying and answering a few questions?
Yeah. Yeah.
Okay. So how is a trust implemented? Okay, so the parents die, or the grantors die, and then the trustee, the new trustee, the successor trustee takes over. How is the trust actually implemented?
Sure. Yeah. And I guess there's a few ways you could look at it. So from one perspective on the front end, when you form your trust, implementing it basically means that you've signed it, you've gotten it notarized, and then you put your property into it. And that's basically it. Then the trust is ready to run. When you die, just like Dawn said, that's when the successor trustee jumps in and they start operating the trust. And anything in the trust, they have authority over. And they'll actually get this document called a certification of trust. That's kind of like the, hey, this asset that's in the trust, I'm the trustee, I'm in charge, you can do business with me. And that's what they'll show banks if they need to do things with the banks, or third parties if they need to sell a property or something like that according to your instructions. So they go around with that document that shows that they've got the authority and they carry out your wishes. While that's happening, your beneficiaries are acting kind of like watchdogs, because if the trustee does anything squirrely, the beneficiaries can have them removed and put somebody in who will follow the instructions.
Okay. Thomas is asking, and let me re-emphasize. When I talk about trust, I like the analogy of a great big Tupperware bowl. And everybody has one, but you never put it in the cabinet empty. You always put all little Tupperware bowls inside of it, put the lid on, shove it away. You nest things inside. But the general rule is a trust can't own a trust. It can be a beneficiary, but it can't own a trust. An IRA, a 401k, those are trusts. There's beneficiaries. So you don't put an IRA inside of a trust, although it could be maybe my IRA, my wife is the beneficiary. Well, I guess I set it up for my benefit when I retire. She's the contingent, and the trust is the second contingent. So we can do it that way. But other than trusts, yes, I have an interest in an LLC that goes into my trust. I have an interest in a corporation that goes into the trust. My home goes into the trust. My bank accounts, the small ones, the big ones. If I've got big savings accounts, that might go in a limited partnership or an LLC, which my interest comes down into this big Tupperware bowl, and it's going to collect everything and it's going to distribute according to the terms and the values that I've created in the trust. Jonathan, do you want to add to that?
Yeah, that's great. I like that Tupperware analogy. That's exactly right. So you name the trust as beneficiary on other trusts, like your IRAs, your Roths, your solo 401ks, life insurance, that kind of thing. But then anything else can either go straight in the trust, or if it's something valuable you want to protect, that goes into some kind of an asset protection entity like an LLC or limited partnership, and then that goes into the trust. That gets nested into the big Tupperware bowl.
There we go. Thank you. All right. Can spouses set up this? I think we've answered this. Can spouses set up separate trusts, or do they do a marital trust? And the answer is, it depends.
Right, exactly. So the joint trust really only works for people who are legally married. If you're just kind of if you just have a life partner or something like that, you're not legally married, or you don't have a common law marriage, then it doesn't really work very well from a tax perspective. There can be some issues there. And we can tease that out in the one-on-one to really see what your situation is to make sure we're setting up the right kind of trust.
And whatever the laws of your state on what marriage people, just follow the laws in your state. What's this difference between a living trust and an irrevocable trust?
Sure. So the living trust is revocable, and revocable means you can get rid of it at any point, and you could also change it for that matter. So the reason we really like these living trusts is you can set them up now, put all your property into it, and let's say you have some more kids or your preferences change and you want to change out who's getting what. The trust is still changeable right up until you pass away. So you're free to do whatever you want with it. An irrevocable trust, on the other hand, once you set it up, once you put property into it, it's set in stone. And that's why they're sometimes used for estate tax purposes, because it gets things out of your ownership permanently. But that also means they're a one-way street. So you got to be really careful with those. So the revocable trust, again, that's your foundation. You want that first. And then if you have a need, the irrevocable trust could be kind of an ancillary to it.
And James, there's something on our website about this, because I spent some time on it teaching this. There's trust, there's so many hundreds of names, and it's all marketing crap, but they're either revocable or irrevocable, and they're either created while you're living or they're created after you're dead. So revocable, irrevocable, living or testamentary is what they're called if they're created after you're dead. And so what you're asking is, you're kind of asking two questions, but generally we refer to a revocable living trust as our main estate planning document. Irrevocable trusts are specific to, generally we don't do a lot of estate planning because you're pouring wet concrete, you're not going to change it. And once you've created and funded that trust, so we still like them for life insurance, charitable remainder trust, things that aren't going to change. But are my kids going to stay intact? Are they going to stay married? Who's going to pass away first? And there's so many things we like revocable living trust for most of our estate planning, because they're flexible and fluid, and you can change things around. And irrevocable trusts are just that, they're irrevocable. Any thoughts? Are we good?
No, that's exactly right.
Cool. Great presentation. Thank you. I think this is vital information. How do I protect the house I live in? Because it's only under my husband's name. Is there a way I can make sure that if anything happens to him? Wow, we spent a lot of time at the 3-day summit, both Clint and I, talking about how to protect your home, and it's state homestead laws apply, and it's the most difficult of all assets to protect. But I don't know. Do you want to take a stab at it in 2 minutes?
Yeah. So I'll focus a little bit on the second half of the question there. It sounds like you're worried about making sure that it's protected from the perspective of, when your husband dies, you don't just get kicked out of the house, right? Well, there is a way that you can have that built into the trust. You can actually have language in there that specifically says either the house stays in the trust and the surviving spouse has a right to live there until they pass, or it specifically gifts the house to the surviving spouse and then it's theirs and they can do whatever they want with it. So depending on the circumstances, what you and your spouse feel is right, either one of those options will protect you and let you keep living there.
Is that a transfer on death deed, or what do you call that?
Sure. So it's either a specific gift or it's called a right of occupancy, and that's built into the trust language itself. So you can still just deed the property to the trust with just a regular old warranty deed, and then the trust itself takes over and makes sure that the surviving spouse is taken care of.
Okay, good. For large estates over 40 million, do you set up irrevocable trusts to remove the assets from the estate? I think we've answered that yes. If so, how much does it cost to set up an irrevocable trust? What about future changes? How are additional costs incurred?
Sure. So if you've got a big estate, the first step is you still want your revocable trust in place because that's your foundation. And then if you've got an amount that's going to be up above the estate tax exemption, then yes, that's where you typically use some irrevocable trust planning. something like a charitable remainder trust, like Don was mentioning. You've gotten in here an intentionally defective grantor trust. That's another a little bit more robust option as well. There's also the ILETs. There's also the spousal lifetime access trust. There's all kinds of interesting things out there that you can do, but they're very situation specific. So as far as costs go, they vary quite a bit because those trusts take quite a bit of work to put together depending on your scenario. Now, when we set up your revocable trust, we'll be talking with you about that kind of stuff to see if you've got that kind of concern. And if you do, we'll get you with our guys who really focus on those irrevocable trusts to get you set up right. Now, if you try to go to them first, they're going to ask you, do you have your revocable trust set up? And if you don't, they'll be like, all right, go do that first. That needs to happen. And then we'll talk to you about this more advanced planning for the estate tax.
Okay. Is it important to add an asset with a beneficiary attached to the trust? I'm not sure I understand the question.
Yeah, so this might be referring to beneficiary designations on IRAs, QRPs, life insurance.
Okay.
If that's the case, then you have to ask yourself, who's the beneficiary? If it's your spouse, then usually there's some tax benefits to doing that, so that's fine. If it's a child or somebody else, you really want to just hand that asset to them because that's what it'll do. It'll skip probate, but then it drops it right in their laps. What if they're under 18 or maybe they've got some legal issues come down the pipeline or some substance abuse concerns? They're just going to use that to fund that habit. So if you've got any kind of concerns at all about just handing the asset to someone, have the trust as the backup beneficiary after your spouse. That keeps it in the trust. And the trustee can monitor that and make sure the beneficiary's actually going to get the asset to their benefit, not harm themselves or have it taken from them or something like that.
Giving an asset to an 18-year-old, it may not be in their best interest, or giving it to somebody where their marriage has not been stabilized may not be in their best interest. So
Right.
I think really good advice. What if I have a trust? I mean, live in California, then I move to another state. Does the trust need to be restated at that point? Or what do you suggest after a move?
Sure. So generally, no. If all you're doing is moving and that's the only change, then all 50 states and DC will recognize a properly formed trust in any of the other states. So if you set up a California trust and you move to Florida, Florida is going to recognize the California trust. Now, again, we generally recommend going with Nevada because Nevada's got more flexibility, more options. There's even some really interesting asset protection perks in Nevada that you can take advantage of. And then that Nevada trust will just follow you around wherever you end up.
Okay, which brings you to the next question. Are there reasons why I should have my trust made in Nevada as opposed to the state where they live?
Right. So Nevada, as a general rule, just gives you more flexibility, more options. You can do more interesting planning with it. I suppose if you just wanted to do something fairly straightforward where you avoid probate, you make sure that the kids are okay, and then it just kind of hands it to the kids, then you could set up somewhere else. But generally speaking, Nevada is just going to be a better option for you because you can do more there. And again, there's some asset protection perks that we can get into in the one-on-one. As far as setting it up in any other state, Nevada really is the most competitive one right now. There are some states out there, I think South Dakota is one of them, of all places, that's trying to get a bit more competitive, but Nevada has just kind of been pushing the envelope as far as that stuff goes. And until it changes, we're going to keep with Nevada.
Let me go back to Sandra's question about moving. If I live in a state, set up the trust and then move, and you're absolutely right, except when all your assets change. The fund, I moved, I've got a new house, I've got a new business, and so the trust may not have to be restated, but the assets need to be refunded. Make sure that we're funding the new house, the new businesses, whatever we have in the name of your trust. And the name of the trust won't change, but the assets most likely will. Okay, keep going. My mother in Chicago set up a trust about 20 years ago, but I can't find the signed document. Whoops. However, the estate planning attorney set up some of the major assets in the trust. what happens if my mom passes away and we can't find a copy of the trust?
Yeah, yeah. So this is a bit of a sticky situation. And that's why, generally speaking, we'll tell people, hey, keep those originals somewhere safe. A fireproof safe in your home, a safe deposit box, something like that. Make a photocopy and have that photocopy in the home office, easy to find with some instructions on where the originals are. But keep those originals somewhere safe, because that's the really controlling document. If ever push comes to shove and you need to prove that the trust says something because someone's fighting you on it, that's the one that the court's going to want to look at if things do get out of hand to that point. Now, for most trusts out there, you're never going to see the inside of a courtroom, so that doesn't typically happen, but it's better to be prepared and make sure that the document's safe.
What my parents did, and what I've done with my kids, is everyone got a copy of the trust. There was no Hollywood drama, surprise, here's what you get out of it. Just cut the drama crap and be honest and be open with people. And there might be multiple copies, so that your copy, the only copy, doesn't get lost. But avoid the drama. I don't know, your thoughts, any?
Yeah, exactly. So I've seen families do that, where you hand out copies to everybody, or at least people who are going to be trustees. Sometimes people choose not to because they're worried that if they then change the trust and send out updated copies, it's going to hurt feelings or something like that. But that's kind of up to you. As far as that current problem goes, though, often attorneys will have a copy on file. So if you know the firm that made the trust, you could go back to them and say, hey, do you have a copy? And there's a good chance that they will. If not, then you're going to want to grab an attorney to guide you through that process, because there is a way to kind of work through it if you don't have the trust agreement. It's just going to be kind of a special case that attorney is going to have to walk you through.
Okay, my understanding is that if you put assets in a living trust, those assets cannot be clawed back by Medi-Cal. Is that true? And that goes back to your 5-year rule, does it not?
Right. And it's not a living trust. It's an irrevocable trust that's set up specifically for Medi-Cal or Medicaid. And those trusts are kind of a bear. They're their own animal. We generally don't recommend them here at Anderson because they're so easy to mess up and they're so very unlikely to go right. It's kind of a fun thing to think about, getting your long-term care paid for by the government and then just kind of sticking it to them and saying, hey, you can't get any of this stuff. It still goes to my kids. But the reality is it just doesn't work out very well, and it's so easy to mess it up. So as a general rule, we caution people against it and say, take a look at long-term care insurance or another alternative like that instead.
Okay. We are going to go for another 7 minutes, whether we get all the questions done or not. I'm sorry. I don't want to keep people on the East Coast. It's getting very late. And so we're going to do our very best. But if we can't do it, I'm going to refer you back to the summit where we do answer all these questions, or refer you to Anderson and let them answer it. Can you please address how a trust is affected or not by a nonprofit 501c3 ministry? So that the ministry continues. Oh, good.
Sure. Yeah. So a 501c3, being a nonprofit, doesn't have any owners. So the trust isn't going to be attached to the 501c3 in any way. It's not going to be owned by the trust or vice versa. But you can name the 501c3 as a beneficiary of the trust. You could even do something really cool called a contingent beneficiary, where you say, okay, well, I normally want everything to go to my kids, but let's say doomsday scenario, my kids are gone. They don't have any kids of their own. There's nobody to leave the property to. Well, then that's when your contingent beneficiary kicks in, and you could say, I want it to go to my ministry at that point. And then the whole thing would kick out to the ministry.
Perfect. What if one chooses an attorney as a trustee? Can one designate an amount of limit the amount that they can charge as trustee fees?
So technically, yes, there's provisions you can put into the trust that govern trustee compensation. So if you do hire a professional trustee, a lot of banks and financial institutions out there have trust branches that do this stuff. Attorneys, CPAs will often offer it as well. but you can't force somebody to be your trustee. So if your terms aren't agreeable to that professional trustee, they could just say they're not going to serve, and then the court has to step in to find somebody else. So if you're choosing a professional, we'll typically have you reach out to that professional and ask them, what are your terms? So we can get it all in writing. We'll put it in the initial draft of the trust so they can review it and then give it their blessing or not. And that way you're not going to get stuck in this awkward situation where you were counting on a trustee who's now refusing to serve.
Because you were too darn cheap to. Yes, and so you can limit the amount of fees and also limit the time that they're allowed to I don't know, whatever, get rid distribute the assets. There we go. Can family charge as a trustee? Yes.
Yes.
You can put those limits in as well. Will a Nevada trust still be valid? By the way, if they wanted to take advantage of your offer, Kendall, is that still in the chat screen, that link?
Yeah, it's there. I'll put it in one more time, but it's there.
Okay, take advantage of that. Jonathan, do you want to go back to your slide right before and hit that one more time, and then we'll finish up with the last couple minutes of these questions.
Yeah, absolutely. So is this the one you were talking about here?
No, I'll go back one more.
One more. Okay.
There's what it all includes.
Yep, exactly. So
the trust document, the powers of attorney. What about the funding documents?
Yes, so we'll include those too. Those aren't quite as exciting as some of this other stuff, so I didn't spend any time on it. But yes, we'll talk all about funding in the one-on-one. You'll get funding packets, guidance. We're there for questions along the way too. The funding is still going to be your responsibility because we can't grab your assets and put them somewhere. Banks typically don't like that sort of thing, but we'll be there to tell you how to interact with the bank, what documents to use, and then answer questions if they give you any trouble along the way.
Okay, where do I love this question about a certificate of trust. I think the most valuable thing, the whole thing, because generally if you go to the bank, they want to see the copy of the trust. No, it's none of your darn business. Here's a certificate. That's all you need. It's the Cliff Note version of the trust that you give to the banks, and maybe the county recorder or something. But I would be very wary about giving them your whole 40, 50, 100-page trust. Where do you get the certificate? Do you include a certificate with this?
Yes, we do. And just like you said, it just gives them the absolute bare legal minimum information to keep the bank from stonewalling you. It doesn't give them anything about your beneficiaries, who's getting what, any of that nonsense. So everything else is private. And that document, they legally have to accept it. Like that's state law. So they can't give you any trouble if you hand that over and it matches what the state requires. That's the only thing they can look at.
Love that question. Thank you for bringing that up. It's a very important document. And Jonathan, I'm glad you're including that. I'm trying to show that I'm an accredited investor. If my assets are in the trust, how do I prove my accreditation?
Sure. So for tax purposes, income tax purposes, and just general legal ownership purposes, you and your living trust are one and the same. You guys are like alter egos of each other. So when it comes to proving your accreditation, if it's in the trust, you own it. So there's no nonsense, no garbage that you have to worry about. Now, that's not the case for irrevocable trust. So that's another thing you got to be careful with. You can't count irrevocable trust assets as yours. So that's why, again, start with the revocable trust, and then we'll talk to you in the one-on-one if an irrevocable trust is actually applicable to you.
Good. If we put properties in investments and wow. It means no, maybe you can help me with that one.
Yeah, so I think they're asking if we put things into the trust, does that protect them from lawsuits?
Yeah.
Now, the other thing is you and your trust are one and the same for legal purposes too. So the trust by itself isn't asset protection for you. It might be for your beneficiaries after you pass and their inheritance is in the trust, but not for you while you're alive. That's why you still need the LLCs, the asset protection entities, to be those other bowls inside the big Tupperware bowl, because that way you get the asset protection and the estate planning.
And there's no asset protection because it's revocable, it's amendable. You can move the assets out, in and out 46 times a day. If you have access to those assets, so does a judgment creditor. An irrevocable trust does provide asset protection, but it's irrevocable. I don't have access to those. And so that's why we use sometimes LLCs to hold, or limited partnerships to hold the assets. That's our asset protection label or level, but everything ties in to your big popcorn Tupperware bowl. So good question. Can a foreigner who owns U.S. real estate set up an irrevocable trust in the U.S.?
Yes. So you can set up a revocable trust to own your U.S. based assets. That's the only thing U.S. trusts can do, though, is handle U.S. based assets. It can't handle anything outside of the states. Other countries won't recognize the trust as far as those foreign assets go.
Perfect. Do you have to register your living trust in Nevada?
No. So the trust is a completely private document. There's no registration requirements. There's no filing fees, renewal fees, or any of that. Once you sign it, that thing's good to go until you decide to get rid of it.
And Jan, the only exception that I know is that in Idaho, your trust has to be registered with your county recorder or something to be legal. And I don't know all the rules, but Idaho is a little bit different on trusts. That's the only place that I think you register it with the state or county agency. But Jan, I know you don't live in Idaho, so disregard that. Okay, there we go. And finally, I'm putting in offers, looking at Virginia loan and other loan. The office of the loan department says I can protect my new address with the trust at closing, provided it's not a funny trust. What is a funny trust? Does Wyoming or Nevada constitute a funny trust?
Yeah, funny trust isn't really a legal term that I'm aware of. So I'm guessing they were just saying as long as it's nothing too out there, and they're probably talking, maybe sovereign citizen type trusts, that kind of stuff that's out there on the fringe. No, the Nevada trusts that we set up, those aren't going to be funny. Those aren't going to be weird. You can absolutely close on properties in the name of this trust, as long as your title company or lender's good with it. Now, you can transfer properties to the trust, especially your primary residence, and there isn't anything the lender can say about it, generally speaking. They may still want you to close initially in your name, and then you can transfer it to the trust, but that's covered by a federal law.
Yeah, and Trey, generally, I think they're talking about like land trusts. You get the financing in your name and then transfer the property if you need to into, but a revocable living trust, no, you can get financing because you are the trust. The trust is you. There's no difference. But if you're using irrevocable trusts or land trusts or other things, maybe that's what you're referring to, get the financing in your name and then do the transfers. Okay, we keep getting questions. Can I move an asset from trust to personal name if needed? Yeah, it's revocable. It's amendable. You can change it and revoke it and move assets in and out and in and out and in and out all you want to. What are some practical scenarios? I'm going to leave that to your consult with Anderson. We're really out of time, and let's do one more. I already have a living trust. My trust was created without an attorney. It is clear now that I need a custom drafted living trust. Would you charge me additional fees, or your current offer would it cover my situation? And Eva is such a great question. When I was first married, we just had a simple trust. It was a fill in the blank. It was, and it worked. But then things got complicated, and my daughter had some medical issues, and some of the kids had been through college and some of them hadn't, and things got really complicated. And at that point, I didn't want to rely on a fill in the blank kind of do it yourself trust. There's a point in life where you graduate, and and will Anderson review your trust and amend it? No, it's probably time to start over and have an attorney do it right. Jonathan, you can answer that better than I can, but
Sure.
there's a point where you have to graduate in life and just suck it up and do it right.
Yeah, and we'll absolutely take a look at your specific situation to see if it's worth keeping the old trust and restating it. If that is the case, that's covered by this particular offer. So we'll do the restatement too. Usually the only time you would do that though is if you've transferred everything you have to the trust already and you don't want to have to redo all of that work. So we would keep the original trust name, the original trust date, and we'd restate the agreement. So replace the documents themselves so the new instructions are more comprehensive like you want.
Okay.
And then that way you just kind of plug and play. All the assets stay in the original trust name. You don't have to retransfer anything.
Jonathan, you have been absolutely delightful. Thank you for your information. We have gone way over time. And for those of you that did get your questions answered, contact Anderson. Go through or give us a call on the hotline and we'll answer them tomorrow. But in fairness to everybody that's on the call, we do have to put an end to this. Any final closing remarks, Jonathan? I so appreciate your expertise and taking time, especially the extra time. Thank you for that.
Yeah, of course. It's been a blast. Thanks you guys for having me on. And, again, we're all about education. So if you guys are still just kind of kicking the tires, not really sure about Anderson, feel free to keep looking at us. We're going to keep this offer open for you though. So if you feel like this is right for you, if this makes sense for you, then yeah, click that link, use that code, and we're happy to start working with you and get you taken care of.
Thank you very, very much for your time. Students, thank you for staying on. Thank you for your wonderful questions, and we appreciate your loyalty. Join us at the next 3-day summit. We get so much more to talk about. Anyway, thank you for being with us. Have a pleasant evening. Good night now.